Jeremy, are we right at 1? I think we are. We can
Looks like we are right at 1.
Okay. Well, I will kick things off here. I'm sure we'll get some more people joining as we go. Jeremy, do we want to wait a couple minutes? Always never sure if we should. I hate to hold people hostage with their time, I know, but.
Yeah, it looks like a significant chunk of the committee is here at least. I think we can start with at least a roll.
Okay.
Whenever you're ready to proceed.
Yeah, let's go ahead and get started with that.
Great. So I will read 2 different roles. The first will be committee members and their alternates. The second will be other ACUS members. So starting with committee members, when I say your name, please just unmute yourself and say here so we can test that your microphone is working. Kent Barnett.
Here.
Jack Bierman.
Here.
Eric Benderson. Michael Cole.
Here.
Annika Cooper. Not here. David Engstrom. Claire Evans. Chai Feldblum.
Here.
Susan Sui Grunman. Janice Hoffman. Renee Landers. Tristan Levitt.
Here.
Richard Layton. Robert Lesnick.
Here.
Jeffrey Lubbers. Alex Manuel.
Here.
Thomas McCarthy. Kareth Cohen for Melissa McIntosh. Jay Ortiz for Patrick Nagel. Roxanne Rothschild.
Here.
Robert Schiff. John Vitone. Chris Walker. David Welch.
Here.
And Russell Wheeler. And for non-committee members from ACUS, Bill Funk.
Here.
And Eugene Smith. Great. That should be everybody. Back to you, Nadine.
Okay, great. I'm going to throw this over to Matt if he'd like to say a few comments to just get us started off on the right foot.
Very briefly, thank you, Nadine, and thanks for all of our committee members and also Bill Funk for joining us. We have a very good group here. I can't think of a more important and certainly timely project for ACUS at this time. And I can't think of anyone better as a consultant to help us with this than Fred Lederer, who's returning to ACUS for, I think, his 3rd project with us, but it's probably more like, maybe more than that. And so welcome, Fred. Thank you very much. Fred helped Paul Verkyle launch our video hearing initiatives back in, I don't know if it was 2011 or 2012, but he's been with us for a long time and he served the conference very well. So thank you, Fred. It's really great to have you here. And then the only other thing I would like to say, I would like to thank Jeremy for contributing a report to us. I think it was mid last year on some of the legal issues associated with video and virtual hearings, remote hearings generally. That report too will serve the committee well, and it is on the project page for this website. If you haven't read it, I certainly commend it to you on some of the legal issues, including some of the due process issues associated with remote hearings. So with that, Nadine, let me turn it over to you, and I guess I should thank you for chairing yet another meeting for us. You always do so well for us, and we're very, very happy to have you as a committee chair.
Thanks, Matt. It's my pleasure. It's a great group. And I'm looking forward to this. This is great. We're going to discuss a very timely.
This is the fun committee. This is actually the fun committee. Yeah.
I'm glad we have that reputation. I just think it's great. We're going to be talking about something very timely and relevant as we kind of see this post-pandemic future ahead of us. You know, the time is now for assessing what we've learned about this world of virtual adjudication over the past year and seeing what we can carry forward as best practices. So you're going to hear from Fred shortly about the research he did for this project, and I hope you've had a chance to read over his informative report. I was happy to see mention of possibly the most famous virtual attorney of the past year, that poor soul who appeared as a talking cat in court. If you haven't seen it, you must. It is priceless. So before we get down to the work that's ahead of us, ground rules, I am required to cover them with you, and bear with me here. Please note that only ACUS members, whether or not on the committee, and their designated alternates have full speaking privileges. ACUS members are government members, public members, senior fellows, liaison representatives, and special counsels. Please, to avoid background noise, I beg you, keep your microphone on mute. And you can use the hand raise feature in the chat. If you've been on Zoom, you know where that is, or add a comment in the chat feature if you would like to speak. And I can call on you. You can unmute yourself. And when you're finished, you can remute yourself. I ask that ACUS members and their designated alternates please use the webcam, the video, if you can. It's great to be able to see people when we're having our conversations. With respect to attendees other than ACUS members and alternates, your participation requires the unanimous consent of the committee members. So time permitting, I will consider calling on such attendees at appropriate points, and we will presume that my fellow members consent absent raising an objection. If any such participant would like to speak, please use the chat feature or raise your hand using the hand raise feature. And please wait until I call on you. You can unmute yourself, say what you need to say, and then remute when you're done. For all participants, a reminder about the chat function. Please use it only when you are indicating that you'd like to speak or vote when the time comes. We'll cross that bridge later. Please do not hold any sidebar discussions or substantive comments in the chat feature. Only members of the adjudication committee have a vote. Please do not vote unless you're a member of the committee. And Jeremy and I have that list in case you're not sure where you fall. I think that covers all of the ground rules. And so I am ready to turn to the report itself. I guess my first thought was to ask if there are just general comments or thoughts generally before we do our usual line by line that anyone wanted to weigh in on. Oh, I'm sorry, I forgot about Fred. Jeremy, just slow me down. Please, we want to hear from Fred. I got so caught up in the ground rules. Fred, please tell us about your report, the information you found out before we get into general thoughts. Sorry about that.
Thank you. It's an honor and a pleasure to be with all of you, and I'd like to particularly thank Matt, Jeremy, and ACUS for the opportunity to work on this fascinating and so very important project. So let me be brief. First, and if you had a chance to read the report, you've already seen this. I had the opportunity and the pleasure to interview senior representatives of 12 agencies, including the National Labor Relations Board, that somehow was left out of the footnote, and found myself with a unanimous view in this very difficult area. Everyone agreed that virtual proceedings, including virtual hearings, had proven to be useful and well worth doing. That didn't mean there weren't difficulties. As to whether they plan to do this post-pandemic, may that day come soon, the answer I had was yes, subject to, and then the subject varied by agency. Generally speaking, what I heard, and this was almost verbatim at least twice, this is a really good tool to have in our toolbox, and we are likely to continue using it when we figure out what will make the most sense. And then usually I had an explanation as to what that might be for that agency. So that was the good news, if you will. What were the difficulties? And the difficulties were pretty much unanimous as well. First, everyone, of course, reports what we are politely calling glitches. Difficulties based on sudden internet issues, equipment problems, the necessity to have to help people prepare for the hearings, and the rest. No one seemed to feel that this was a massive showstopper. Quite the opposite. There was, again, a substantial amount of agreement. I don't think anyone ever disagreed. Almost every agency representative raised this, that to make all this happen, and I'd like to add, the amount of effort that all agencies have taken, and a number in particular, to adapt quickly to this is truly extraordinary. There is no way I think this country will ever become aware of it, and thank you all, but it has been extraordinary. I've said it twice, I apologize. And to do this, staff members, particularly lawyer staff members, have been used to not only do the transition, but to support the proceedings and hearings. So that customarily, many of the agencies are setting up advanced meetings to go over not just protocols, but to make sure the equipment works. And virtually nobody, sorry about the double entendre there, had ever planned, of course, to use these people for this purpose, which means that we are diverting scarce critical labor. And then, of course, we have also had occasional comments about how do we keep current with all this technology since it keeps changing, and that's an issue. We've had one comment made after the report, but there were some comments during my interviews talking about the potential use, particularly if you're using Zoom, of the record feature, which is a matter that I think we need to inquire more deeply into. I've already begun talking with the Zoom management about their views of how that might work. So that is my quick summary. Basically, while people are coping on a daily basis with minor difficulties, everyone says this is working really well. And I might add, a very large number of people also concurred by saying this is changing the perception of particularly lawyers about the use of technology and making it easier for us to use technology.
Great, thank you. Thank you very much, Fred. I think your point is well taken about diverting resources and staff becoming experts in areas that they really weren't experts before, in terms of the technology and how to manage it. With that, let's see if anyone just has some general comments about the report or the recommendation.
I had something on the first line of the recommendations, if it's appropriate. It's a general comment.
Okay.
Okay, so my general comment is the way that the recommendations read to me, it seems to express a preference for virtual hearings, and I'm not sure that we wanted to. That's what we wanted to say. I think that we could, I had sent Jeremy an email whether we maybe insert the word only after the word hearings in line 102, and then have a separate sentence saying something like, for reasons involving efficiency, convenience, conservation of resources, and fairness, virtual hearings may often be a desirable alternative to in-person hearings. I mean, because the first sentence, as I think Jeff Lubbers also mentioned this in his comment, seems to express a preference for virtual hearings, which I'm not sure we really want to say at this point.
I'll just say I read it as an option, you know, you should offer it as an option, but maybe the idea is that it's not necessarily going to replace an in-person if that's preferable. Fred, do you have any thoughts on that in terms of the input that you received from the agencies?
It varied by agency. It appeared to me that all the agencies plan to continue using virtual proceedings. The degree to which and for what specific purpose varied. The one thing
Okay.
that came out consistently was, although there are institutional reasons for occasionally traveling to a given location, which at least one agency thought was especially important, generally speaking, the ability to conduct proceedings without the lost time and the cost of travel was considered to be a matter of great importance. And in effect, to make this more available to individuals, whether or not represented by counsel. It also indicated, I was also told by, at one meeting, this was making it easier to recruit adjudicators as well. The elimination of the need to travel and the cost was a massively important issue.
That's interesting. Hadn't thought of that wrinkle. Hi, I see you have your hand raised, so please.
Yeah, I wanted to also state that I think we need to be really careful in this report and the recommendations, and when we get to them, had a few ideas on this, to make it clear that although I completely agree, and I've heard this, that agencies often were very happy with having these virtual hearings and what it saved them, the people participating did not always feel the same way. And that doesn't mean that they shouldn't happen. And in fact, you know, I am quite a believer in them, but I think number one, in terms of how we describe it, we really want to make clear that there can be balancing. And then in particular, and when we get to it, that if people don't want to participate, that there's not only some process, which we have in there, but some sort of standard about when agencies are going to say, no, you have to do it virtually anyway. So general comment, and then as we get to some of the particular places, I hope we talk about it.
Thank you. Okay, I see Roxanne has her hand raised. So please, Roxanne.
Thanks. Last week, partly because we really felt we needed to, and also it was good timing given that ACUS was having this meeting, we had a big town hall meeting for all of our administrative law judges to talk about how's it been going? What do you think about it? What do you think about the future? And I would say that Jack raises a good point. I don't know that we would approach it along the lines of we're offering virtual hearings going forward. However, it will, as Professor later said, be a tool in our toolbox. I think one of the important things that the judges are concerned about is that they be able to do it in the future, that we figure out what would be, when would it be appropriate to do so, and that it would be within the judge's discretion to order it. Does it have to be with agreement of all the parties? There was a lot of discussion of that, but I don't think it would ever be something that we offer where the parties can just say, oh, well, let's take that option of virtual. They can raise the issue, but it's still going to be the judge's call. And to Kai's point, and I apologize if I pronounced your name wrong, but one thing we have batted around an idea is doing an advanced notice of proposed rulemaking where we can just throw it out to our participants and say, tell us, how has this been working for you, and gather that information before we establish what our guidelines would be for using virtual hearings in the future, because we know what we think. We don't know necessarily what they think.
That's very helpful. Thank you. Any other general comments on that topic?
I have a quick comment, Nadine, and I don't
Yes.
recall if it's reflected in the recommendation. I think it's important to emphasize that some agencies have rules that address this matter, and probably many don't. So Roxanne, the NLRB, for instance, has a very specific rule, I believe, about virtual hearings. And I think on the face of the rule, I don't know if it would be fair to say that they are disfavored, but at very least, cause has to be established for holding them. Is that correct? And I'm not sure all or most agencies are similarly situated in that respect.
Absolutely, we do have a rule, but the rule is very narrowly tailored to individual witness testimony by video conference. It was not contemplated when the rule was drafted that it would be the entire hearing was done by video conference. So yes, there's standards in that rule as to when the judge can agree to allow a witness to appear by video testimony. So at the beginning of the pandemic, a board decision issued saying, okay, because of the exigent circumstances here, we are approving the division of judges conducting virtual hearings, because we didn't feel that our rules at present are broad enough to allow that. But that's just our take on it. In terms of the thought that we would, if we go forward, we would need to tweak those rules so at the very least, so that they can be used for full hearings as opposed to just individual witness testimony.
Nadine, can I offer a comment?
Sure, and then I'll turn to Jack. Jack, I see your hand is raised. Yes, go ahead.
Sorry to have not raised my hand.
No, that's fine.
I doubling back to the question of offer. So I think the recommendations are all, very, very reasonably crafted, but that does really raise an interesting question in my mind in terms of who we're advocating for, right? And so if it's some of these, or at least my overall impression having read the report, is that some of the considerations tied to the needs of the people who are participating in the adjudication, right? The appellants. But again, I think it would be helpful to clarify, not just here, but just maybe to make sure that throughout it's consistent in terms of if we're, just encouraging at all stages, or again, if we're encouraging that agencies should consider utilizing it, or is it being offered to the adjudicators or to the appellants, or who's again, there's a lot of kind of target audiences here, but for that idea of making it available, who is the target for that?
Got it. Jack.
Based on this discussion, I think that I'm not as concerned about what I raised initially. I had one legal question though, which is in terms of when a virtual hearing is legally permissible. I didn't see this. I read the report. Do we have a position on whether a statute that requires a hearing or a rule that requires a hearing allows whether that automatically means it's legally permissible to do it virtually? Because that seems to be something that may be hanging there for some agencies. And my inclination is to say yes, it allows it, but I just want to know if we want to say something about that, or if people have a view on that.
This is something Fred may have thoughts, certainly, but this is something on which Jeremy has some learning, having written a report on the subject. And, Jeremy, if you have a few thoughts to share, it would also be helpful if you might say a word or two about what ACUS has done in the past with respect to remote hearings, albeit not virtual hearings, but just video hearings generally.
Sure. So from my research, I wasn't able to find any judicial statements that broadly found that video hearings or virtual hearings or any form of remote participation violates due process across the board. That said, there might be individuals with certain attributes, there may be certain contexts in which it may be inappropriate. Most courts engage a sort of a balancing test, frankly, just the Matthews balancing test to decide whether that's met in that case. Some agencies have established across the board rules. So individuals who present in certain contexts or certain circumstances, maybe a video hearing would not be appropriate in those cases. But I haven't seen any general statement that these things are violate due process across the board. I don't know if that answers your question.
I was at more about statute, this meaning of the word hearing in a statute, but
Yeah. Statutorily, again, from what I've seen, judicial opinions have sort of deferred to agencies on this. The only case that I've seen, and it's not really adjudication by federal agencies, is in the IDEA Act, the IDEA hearings. There's been some interpretation of that statute. They require some sort of in-person confrontation of witnesses. Otherwise, hearing has been interpreted rather broadly, unless it specifies that it must be held in person.
Thanks, Jeremy. That seems to ring true to me, not having done the research as you have. But so I know we have two people who are interested in making a comment. Judge Lesnick, I think we'll go with you first, and then I see Judge McCarthy also has his hand raised. So please, Judge Lesnick.
Thank you, Nadine. I wanted to mention in response to some of the questions, my former commission does have statutorily a requirement that hearings be held near the mine site. And so absent extreme circumstances, that's necessary. I was going to associate myself with Jack Beardman's comments, but then he changed them on me. But at any rate, I think we should put less emphasis on what the agencies want, very little, in fact, and less on the judges and more on the participants. And I only have anecdotal support that most participants want an in-person hearing for the same reasons we use the trappings of office, like a bench, a robe, elevated bench, and so forth. I think it all contributes to the citizen who may only have one meeting with their government in their lifetime, or two in front of a U.S. administrative law judge primarily. Having in-person hearings makes them feel they're being respected and listened to, and the video hearings, I don't think, convey the same feeling. So those are my personal views.
Thank you, Judge. Judge McCarthy.
Thank you, Nadine. I was just going to say that based on the research that I have done, I think the courts looked at Federal Rule of Civil Procedure 43A, and that at trial, testimony must be in open court unless the federal statute, the Federal Rules of Evidence, or other rules adopted by the Supreme Court provide otherwise. But for good cause, much like Roxanne said, an agency may permit testimony in open court by video teleconferencing. And I think during the pandemic, that's what most agencies relied on. Be an interesting question as to whether there's a challenge post-pandemic. I'm not aware of, it's a question of whether we're out of the pandemic or not. I'd also like to associate myself with the comments that were made about allowing the judge at the agency the discretion after balancing the benefits, the disadvantages, and the challenges of a remote hearing or video teleconferencing. And just one final comment, when we look at recommendation 1 in paragraphs A through H, I think often we're looking at the adverse effect as opposed to the potential enhancement. Now, maybe that's because we list the significant benefits, but I don't think we want to either go, pro or con at this point, but allow it to be a matter that's either offered or within discretion after consideration of the appropriate factors. Thank you.
Thank you, Judge. Fred?
The nature of the study didn't permit us to survey the individuals appearing before remote hearings. That's a matter that I think we ought to consider doing eventually when we do have time. But I would like to respond politely and respectfully to Judge Lesnick's concern, which has been highly traditional in the courts, as well as I think in agencies. What we don't know is the impact of the pandemic. What we know is an enormous number of people have now turned to video conferencing for communications and work of all types. So it is just possible that the very people who would have felt dismayed, for want of a better word, if they were not offered an in-person hearing, might now believe either this is perfectly fine or that they don't have to travel and this is better. And indeed, some of the people I interviewed spoke about the importance of providing to the individuals that the agencies serve the ability to make this easier and less expensive. I only speak to point out that we may be in the midst of a national proverbial sea change. And I simply don't know if that's true, and if so, to what degree.
Thank you. Okay. I think this is probably a good general framework to keep in mind as we start to work through the recommendation. So if you have further thoughts along these lines, maybe we can channel them into working line by line through the recommendation. It might, well, trying to decide whether it's better to start with the recommendation itself or move to the preamble first. And to the extent that the preamble sets the stage for the recommendation, perhaps we should start there. So let's go all the way up to the first paragraph. And I'll just note, Jeremy's put these comments in very helpfully to remind us that much of this is covered and established in prior recommendations. So I'm not sure how much there is to change since it's already pretty much set, but I will open it up to discussion of just the entire first paragraph. So lines 1 through 11, any thoughts there? Judge McCarthy, do you have your hand raised again, or is that from the prior time? I'm seeing a hand raised.
I apologize. My hand
No,
is now
it's fine.
lowered. I'm
It's
sorry.
fine. Thank you. Thank you. Russell? Oh, I can't hear you, Russell. Uh-oh. No. Oh, no. Is anybody else not hearing Russell? Is it just me?
I'm not hearing him.
Okay. You're gonna try to go off and come back in. I think I got that. All right. Anything on first paragraph? I'm assuming Russell has something that he would like to weigh in on. Anybody else while we wait for Russell to return? Okay. Russell.
You hear me now?
I do. Wonderful.
Just a suggestion, the second line, this gives the impression the only reason agencies are using this video technology is advances in technology and telecommunications. It just seems to me that's factually inaccurate, that the need for aggregate cost savings and the pressures of the pandemic have obviously contributed to it. And I wouldn't want the first sentence of the recommendation to start off on a sentence that is at best imprecise.
Do you think we should add concepts here or just make it clear that these advances are just part of the small part of the picture.
Due to rapid advances in technology and communications, as well as the desire to save money in the aggregate and deal with the pressures of the pandemic, something along those lines.
Okay.
It just seems to me it's misleading to say that it's only due to
Right. It's incomplete, right? It just doesn't tell you this full story. So I think that's a good catch there.
I wonder also in the last sentence whether we ought to add these various relationships between the attorney and the judge. You know, in the immigration court context, attorneys often have a choice. Do they want to be with their client and risk not communicating well with the judge, or they want to be with the judge and risk not communicating well with the client? I would just add attorney and judge in there somewhere as one of these relationships that communications may be hampered.
I think that's quoting directly from one of the recommendations. So we might be able to fit that in.
If it's worth doing.
Yeah. I'm wondering if there's a spot later on to kind of weave that in, that concern. Any other thoughts on the first paragraph? I'm thinking we can maybe leave to Jeremy and the committee on style, the esteemed committee on style, to work on any language, fine tuning of the language that Russell's proposed adding.
Fine with me.
Okay. Second paragraph.
Well, I hate to keep talking. My only concern there is that we lump legally permissible in with for agencies to consider in with factors which are more discretionary. And it seems to me down at about line 17, 18, you know, a factor to consider, we lump whether it's legally permissible along with whether or not it's conducive to the use of VTC. That's a judgment call. Whether it's legally permissible is pretty much a black and white issue, isn't it?
You would, so you're thinking.
I would say something like appropriate in all, recognize it may not be appropriate in all circumstances and must be legally permissible. The administrative conference has identified factors that eliminate the other one.
Got it.
If I'm missing something, I mean,
Any thoughts on that? I think that makes sense, actually. I'm looking for hands.
I agree.
Thumbs up are always good too. We'll take that. Thank you. Okay. Anything further on that second paragraph? That's another good catch, Russell. You can keep talking. We're fine with that.
okay, the final one would be line 21 or so. Rather than say would create cost savings, I would just say effect. This sentence seems to have is a pro VTR sentence, and I think I would just say affect cost savings. It could go up or down as opposed to whether it would just benefit them. Affect cost savings, productivity, wait times, and access to justice. Because it could have either, it could have a pro effect or a negative effect.
Thank you.
Can I just chime in quickly that I would take the word savings out and just say costs? For
Right.
style.
That's good. Any other thoughts? I'm seeing thumbs up. I love it. Okay. All right, let's move to third paragraph. Great. Looking for hands. Next paragraph.
Are we on the paragraph that starts on line 38?
I see Judge McCarthy. I'm going to see where he wants to land. We may have been on more recently. Judge McCarthy?
I was going to land, thank you, Nadine, on the paragraph that begins with line 32.
Okay.
The last sentence of that paragraph, where we talk about user-friendly, readily available video conferencing software run on personal devices. Again, I want to associate with my comments of not pro or con. This seems to be leaning heavily towards pro. And I think we want to kind of make it neutral.
Okay. What would you suggest we just, is the user-friendly the part that's troubling you? What's,
Well,
where's
I
the whole
think
sentence?
that, I mean, I just, I unfortunately, I don't have
Okay.
a suggestion, but as I read it, it has a slant to it that it doesn't sit well with me. It's very pro, and I want to,
Well,
I'm looking for a neutral, a
Mhm.
neutral balancing consideration of all the factors type approach.
Mhm.
If I can jump
Hi.
in as
Yeah.
Ty,
Yes.
I think
Yeah.
if you just take out using user-friendly, readily available, such as a home or office using using video conferencing software run on their personal devices.
I mean, we're defining, right, what a virtual hearing is. And I think,
Exactly.
the judge is just trying to make clear that we're not characterizing it one way or the other, right?
Correct. And
Okay.
this is just factually what it is.
Great. Kent.
Hi, one question. I may just be misunderstanding the definitional difference between the now virtual hearings versus the VTC earlier. But with the virtual hearing, it says where one or more participants appear from a location of their choosing on software on their personal devices. Well, wasn't that also true under the VTC, where you'd have one person at the site like the judge, but then somebody would be somewhere else on software on another device? Is that wrong?
Fred, do you have a comment in response to this? I see your hand raised.
Yes.
Excellent.
With respect, it is wrong.
Okay.
A centralized courtroom or hearing room was traditionally using commercially available video conferencing, which did not easily permit an individual to appear unless that person was in a similar location. Now, and as this is corrected, this is also misleading in part for that reason. Right now, the same level of commercial equipment will in fact permit Zoom and other programs to interface with it. And we have a number of agencies where individuals are running out of hearing rooms. They're not using personal devices. When Jeremy and I discussed this, I suggested the creation of a new acronym, and I apologize, I know what that means in the government. Computer application-based video conferencing. The key being computer application or computer application video conferencing, CAV. Because that refers to the idea that you are using a computer that is running software. That's the application part that allows you to do video conferencing, and it's all encompassing. But it means that the individual can run it on a computer, a smartphone, or for that matter, interface with a major system in a hearing room.
Kent, was your concern, well, no, I guess your concern was more that everybody's remote in that sense? Was that, that it says one or more participants?
Right. I would think at least one person is appearing from a location of their choosing, whether a home or an office, on some kind of personal device, whether they're using a computer or they're using something else, in either scenario. But if I understand Fred, in the first scenario, they have to be in a similar hearing-like room that's got similar cameras and microphones and speakers and all of that, and they couldn't just simply use a computer to participate. Like, let's say if we had an expert witness on a VTC proceeding, they can't use their computer to participate.
Fred, did you have a?
Yes,
Okay.
with your permission. This is my courtroom. This courtroom behind me was designed exactly for the purpose of remote appearances. Judges, everyone else. Until very recently, you had to be in another location with expensive commercial equipped facilities to appear in this courtroom. Now it is possible to bridge from your tablet, your phone, or whatever. But even so, that was not the reason why this courtroom and all the hearing rooms based on it were created. The assumption was we would connect from another official location. Today, what we're doing the second is it doesn't matter where you are. You're not going to a central location. Our meeting is being held in the virtual world. It does not exist in physical reality. And that's what the change is.
I see, Bill, you have your hand up. Does it relate to this point?
Yes,
Okay.
it does. And it's sort of response to your question to Kent, which was, as I read this, it sounded like we could be including within our new concept, virtual hearing, a situation where we had an actual in-person hearing for everybody except one participant. And that one participant has an iPad and participates in that otherwise real hearing. Now, if that's what we intend to include, then this works fine as the language. But if we mean, as I understood Fred to say just now, that the whole hearing is being done virtually, then the phraseology of one or more participants appear seems to me to give a false impression. It should be that all the participants are participating through this computer assisted software, however we want to define it. So I guess my question is, what is it we are trying to encompass here? The situation, what the entire hearing is virtual, or a situation where just one participant may be virtual and everybody else is in person?
Judge McCarthy.
Thanks, Nadine. I was just going to say in response to Bill's comment that I think from the work that I've done at the conference, the OSRIC conference, and research on the issue, that there's going to be a distinction drawn in the future with regard to 100% virtual hearings and hybrid virtual hearings. And I think we ought to incorporate the definition of hybrid in here, which would be the virtual hearing where some of the participants participate remotely and others may be in person. And I think that's going to be a big part of the wave of the future. So my suggestion would be to incorporate that concept in this discussion somehow, Brett.
Into the term, what the term virtual hearing means, what we're encompassing more than just one person, could be 3 people, could be everyone.
Yeah, well, I think we need to perhaps define what a hybrid type virtual hearing would mean, as opposed to a full virtual hearing, and as opposed to a everybody in person hearing. I think there's going to be a mix going forward, and I think the hybrid approach may be more prevalent.
Should we add a line here explaining that I think as Jeremy's put on the screen here, a virtual hearing could be completely, every person could be a complete virtual hearing, or it could be a hybrid. I mean, I think we can still keep the term virtual hearing, and as long as it's broad enough to encompass the notion that it could mean everybody's virtual or only some people are virtual. Hi. Oh, you're muted. Yep.
I definitely think it's worth explaining for the readers that there has been traditionally, sort of as Frank said, this more, and I got it from the report, but and even from this preamble, but sort of making it clear, this is how lots of agencies did it, and our previous ACUS reporting recommendations apply to that. And what we're doing is now taking it to this next stage to say that there are going to be virtual hearings, or however, whatever term, the computer assisted. I understand that, and we should go back to see if any of the changes that we made still should be revisited. And that while many of the things that ACUS has already said will apply to these as well, because that is so clear in terms of what we've done, there may be some slight differences that we're now asking people to look at. For that purpose, I'm not sure. I mean, maybe let's see as we go through whether we think that those recommendations will change, if they're completely virtual for all or hybrid virtual. Right now, thinking about it, I can't really think that there'll be something that will change, but I think it's worth here saying they could be either of those two ways. And then I'm just saying distinguish. I'm not sure that that difference will make a difference, but I definitely think it's worth clearly noting the difference from what, as Frank described, has been the norm, and then noting just the fact that we've had this discussion to make it clear to the reader, yes, we understand virtual may be either completely virtual or hybrid virtual.
Thank you. Any other thoughts? I mean, I think my first question would be, is the line defining virtual hearing sufficient as it stands now? And then we can add a line kind of explaining a little more what that term could encompass. Does anybody have? Yeah, I see a thumbs up. Any thoughts on language? Judge McCarthy, I'm gonna put you on the spot since you raised the point, but any thoughts about language there that we could add? It is, so I don't know, I'm just thinking off the top of my head. It is possible that a virtual hearing could be hybrid. Somehow get this notion of hybrid in there. Tom, you have any thoughts?
Yeah, I think I would use a hybrid virtual hearing could involve a combination of stipulations, decisions on the record, as well as testimony provided through video conference and in person, something along those lines. I think stipulations, comma, decisions on the record, comma, as well as testimony provided through video conference and in person, period.
Okay. That's just something to get us started. I think that's fine. Thank you. Fred, we'll turn to Fred first.
In the report, I distinguished between remote appearances and virtual hearings. And I used virtual hearings to mean everyone was remote. That might be of some use here, indicating that, a virtual hearing could include remote appearances up to and including everyone being remote, or something on that order.
Is it inaccurate then to say that virtual hearing means any proceeding in which one or more? Should it be in which?
It depends
No,
on, this worked because it was a defining term.
Mhm.
If you're looking at it, if you're trying to be more explicit, then the approach I used was to say that I defined a virtual hearing or as one at which all individuals involved appeared remotely using computer application-based video conferencing. Because agencies have been doing remote appearances for years.
Okay. Does it help for us to not quantify how many participants and just say in which participants and be vague there? And then break it down a little further. Russell? Oh, I'm sorry, Bill. I'm sorry. I'll wait. Let's go to Bill first. I see your hand up. Sorry.
I would leave the one or more in there and then add a sentence following it, almost trying to recapture what Fred said, that virtual hearing can include a hearing in which all participants appear remotely through video conferencing. Or something.
Mhm.
And then we can go on and say it's possible a virtual hearing could be hybrid, in which some, but not all, participants appear remotely through video conferencing. And then
Thank
you
you.
could,
That's great.
and then you can leave in the judge's sentence about could involve a combination of et cetera, et cetera, et cetera.
Thank you. Russell.
No, I didn't. No, I didn't.
Okay. Okay. I thought you were looking for an acknowledgement. No worries. Okay. Fred, did you have any reaction to these changes?
Oh, ma'am.
Any other thoughts? I go back to Kent, who raised the concern to start with. See if there's
I'm
any,
fine with this, and I feel like other people understood the difference better than I did. It just wasn't clear to me that the witnesses had to be at also a hearing-like place when they were doing this. But that seems like other people understood the distinction.
No, I think you raised a good point because it got us thinking about what we really mean here. So, okay. Anything further on these changes here? Okay, let's move on. Next paragraph. I think Russell had something in the next paragraph.
Oh, it's very small on line 45. Facilities to the public and employees. I mean, a lot of government employees were not able to go to work either.
True that. Anything further on this paragraph? Okay. Next paragraph, beginning with line 48. Okay, couple hands. We'll start with Bill. I see you first.
I would add virtual hearings can offer several benefits.
Thank you. Judge McCarthy.
Minor point in footnote 6, I think, Fred, I think you meant to say remote instead of remove appearances. Sure, style committee would have caught that. Is that right?
Seems right to me.
Yep, typo on my part. Thanks.
Happens to all of us, Jeremy. Okay. Hi.
Okay, very small thing, but on line 53, what about putting in sign language interpreters as well? Foreign language interpreters, sign language. No, keep foreign language, but yeah. Foreign
And
language
actually,
and
Jeff
sign language.
Lubbers, in his written comments, had a comment on this point. I think he had recommended removing foreign language
Right.
again at that same point. So that may be something for the committee to consider.
Yeah, I just recalled that as well.
Just
I see
delete foreign
Renee.
language.
Yeah, Renee, do you have a thought on this?
Oh, not that point, but the same
Okay.
sentence, but I'll wait till
Okay.
you resolve that.
Thank
Either way,
you,
it's
thank
fine.
you, thank you. Yeah, I think Professor Lubbers had the suggestion that we delete foreign language and just leave it as interpreters.
Right.
Oh,
Makes sense too.
I'm fine with that as well. It's just, I saw foreign language and of course I immediately thought sign language.
Yeah,
Interpreters are good.
okay. Renee,
Oh, so can we say something at the beginning of the sentence? Can it be something like, something like, virtual hearings or remote hearings, something like that, because this is kind of, disattached from everything.
if that works.
Good.
Thank you. Judge McCarthy?
My bad. I need to lower my hand. I'm sorry, Nadine.
That's all right. I called on you out of turn when you didn't have it up, so you never know. I may just ignore that hand. Okay, anything further on this paragraph? Great. Let's move on to the next one, beginning with line 57. Okay, next paragraph, most significantly. I wondered if we needed heavily in there. We already said most significantly. Jack Bierman would have a thought on that if he's still with us. I know he had to sign off. Anything else here? And I know Professor Jeff Lubbers had a comment here as well, if I'm remembering right, Jeremy.
That's correct.
Anything further before we turn to that? So I think this was circulated to everybody ahead of the meeting. I don't know if you'd seen an opportunity to see it. It's raised in the preamble and then again in the recommendation. Jeff is flagging the reference to individuals who live in underserved communities. And my understanding is that this comes directly, as the comment points out, from a recent executive order. Jeff's concern was saying people who live in rural areas suggests that we are painting people who live in rural areas with an overbroad brush, that it may be better to substitute individuals who live in areas with weak or inconsistent internet access as opposed to their location. And I just point to the EO. I think that's something that the language that the EO uses. It's not something that Jeremy made up. And it's a question of whether we think it's better served to identify it by the language that Jeff has pointed out. Okay, I see two hands. We'll start with Bill.
I like Jeff Lubbers a lot, but on this one I don't agree with him. I think the rural areas it's part of our identity politics today. I'm not sure I love it, but it's what we have. I think we've got to use it.
Okay, thank you. Hi.
I'm not sure I was whether I'm now convinced. I mean, I just remember, I mean, having served on the Biden transition team and hearing a lot of these discussions, exactly that piece. People wanted to say rural areas. On the other hand, I think that we could sort of be adapting it to hear, you know, I mean, you could say person who live in rural area, don't put, you know, who live in rural areas where I don't know, we're in, you know, just adding it instead of just taking it out. I mean, you know, because I'll have to say, you know, I had sort of a reaction to persons with disabilities, you know, like that's painting with a broad brush, even though I very much feel that for some people with disabilities, these virtual hearings are key. But it was just so important in that EO because of how it was written, you know, in terms of racial equality up front, that it was very important to make it clear that it also included these other categories. So I think we could go either way. I don't think it's horrible to say persons who live in rural areas where internet connections may be particularly difficult, because you're then just applying the EO terms to the issue at hand.
Nadine, whenever Kai is done.
I'm done, even I'm not exactly sure what I think. So
Okay, now, yeah.
I might suggest that the committee reserve judgment on this till the next meeting and allow the staff to take a look at the recommendation that we had on electronic case management, which did address the problem of internet access in rural areas. If I recall, it's kind of a vague recollection, but it might be worth taking a look at that to see if any language was used there that might be helpful here. I'm really stretching my recollection here, but I know the issue was discussed in that recommendation.
Thank you, Matt. I see Roxanne has her hand up. So Roxanne, please.
Yeah, I put my hand up before Matt made the suggestion that we put a pin in this. I was just going to say maybe we can avoid rural areas altogether and just simply say persons who lack access to adequate internet access. I hate using the word access twice, but basically that would cover people who are in areas that don't have good internet, people who just in their own home can't afford good internet, or they're competing with the rest of their family for the internet, and so it doesn't work very well. It's just a little broader, and we avoid having to use the rural areas designation.
Bill, do you have your hand up again? Okay, great, please.
Yeah, I mean, I'm going to make a radical suggestion, which is to end the sentence with undeserved communities and leave out all the such as's. Because if we're talking about lack internet access for the rural people, what is persons otherwise adversely affected by poverty? I mean, persons affected by poverty, adversely affected, otherwise adversely affected, but they have internet. I mean, do they have access to what's the problem? We're specifying the problem, we thought, for the rural areas, but we're not specifying it for either disabilities or people adversely affected by poverty. Why not just end the sentence with communities? And I also agree with Matt's comment that we should, you know, have staff look and see if there was a way that was addressed this issue in another report or recommendation.
Thank you. Professor Landers.
Oh, well, I was just going to say, I mean, I think, you know, Bill's idea is fine, but another another set of institutions that's been dealing with issues about spotty internet access or lack of access are the public schools. So, you know, maybe looking at, that's another source of looking at language that might describe the full panoply of situations that we're trying to refer to here.
Any thoughts about stopping the sentence at underserved communities without necessarily identifying or highlighting specific areas? I see a hand up. Tristan.
I like that idea. This is tough again on both sides there. I was inclined originally towards not saying rural, but I think that would help to to apply it to all these situations by pulling that there.
Great, thank you. Any other thoughts?
The only thing I would say to
Mhm.
that is that the advantage of, people, the terminology underserved communities kind of has these connotations that may not bring people's minds to the broad array of situations in which being underserved is an issue. And so, I don't know. I think in some ways, saying a little bit more here rather than less might be useful, especially, if we're going to try to encompass people with disabilities, the rural situation. There are just all kinds of reasons, and that, the average person who doesn't think about these things all the time is probably not thinking of that full range. And we want people to understand how that it's not just, sort of a narrow group that, people may or may not care about.
Fred, do you have any thoughts on this in terms of the barriers to access that the report looked at?
When I did the interviews, I believe I had representatives of two agencies refer expressly to rural. And the way they did so, they were not referring to lack of adequate internet connectivity, they were referring to poverty. And their concern was ability to afford the hardware. I think there was a larger, I can't recall how often it came up, but I think it was a given that there were national problems with inadequate bandwidth for multiple communities around the country. And I think, the president has declared an intent to cope with that. So I'm not sure what I can say beyond that.
Okay. Thank you. Tristan, did you have another thought? I see your hand. Okay, all right. No, it's fine. So if we retained some of the such as language, maybe, I think Bill expressed concern with what the last part was really accomplishing, the adversely affected by poverty. Maybe if we keep the focus on the lack of internet access, obviously with persons with disabilities, government-wide, we take that into account in terms of access to any of our services, in terms of whether accommodations are needed. Is there anything we could add to that one that might be more precise? Looking, I see Hi has her hand raised. I was going to call on you anyhow, given your experience, the EOC.
Yeah, no, I just raised my hand for that. Again, on this, I don't know that you need persons with disabilities here. Number one, I actually think mostly persons with disabilities are helped by this. So, and like I said, literally persons with disabilities was put in the EO in order to include them, somewhere. So I think you can take that out here. I would be comfortable, and even better, probably.
We could limit it to one example and focus on the internet access point as a barrier, as an example of a barrier. Roxanne.
Just briefly to correct my own prior statement, lack access to internet access. I could just say lack adequate internet access and just put in the word adequate and take out access too. I agree with Kai that you don't have to say disabilities. It's really more people who lack technical skills, who sometimes have difficulties, and people who don't have a smartphone, don't have a computer, don't have tablets, that sort of thing. But I think that's encompassed by the otherwise adversely affected by poverty.
So Hi's thought is to take out those such as persons with disabilities. So we would need this still, the such as. Any other thoughts on that line? Bill, did you think that the last phrase should be deleted or revised?
I thought it should be deleted, but I don't feel strongly about it. I mean, it's, if they're, I don't understand what otherwise adversely affected means. I mean, people are adversely affected by poverty. Does that affect their internet access? Probably it does. Do we care if they have adequate internet access? Do we care if they're otherwise adversely affected by poverty? I don't know. It doesn't seem to add anything to what we already have there now. So I delete it, but I don't feel strongly.
Let's delete it and see what people think. So we'd have the one example. Renee, what's your thoughts on this? I know you said you thought it would be helpful to point out.
I think that underserved communities, persons who lack adequate internet access. I mean, I don't know. I thought about that last phrase, and I thought the problem with that last phrase was the word otherwise. You know, persons adversely affected by poverty. We could also say, you know, persons who lack resources to acquire the technology or internet access. To acquire the necessary technology. Just a thought.
Or the resources?
The resources.
Okay. Roxanne.
We could make it shorter if we wanted to say lack adequate internet access or personal devices, because we've talked multiple times here about operating a personal device to get into the hearing. Just say they lack the personal device.
Right. That's right. It's good.
Any other thoughts? Bill, I see a smile. Is that a good smile or?
No, I'm thinking that I don't know how to say this politically correctly, but it seems to me almost everybody has a personal device. The homeless people in Portland have personal devices. They may not have Zoom on their personal device. I don't want to make it shorter. I think the person, I like what we had before with the lacking adequate resources for the technology covers it all. But it was, the smile was because everybody I know, no matter how poor, ends up having a personal device these days.
It's not true.
Annika? I think you're on mute.
Yeah,
great.
That the first sentence and the second sentence can be tied more together, and I think that might help to solve some of our issues, because that first sentence talks about the internet connection, et cetera. And so I think if we started off the virtual hearing sentence with something like, as a result, virtual hearings may create a barrier to access, et cetera. And I don't think that everybody, I don't think that everybody has like a personal device or, internet connections that they can rely on. And so I do think that it is an important point that the recommendation recognize that, people are not similarly situated in that way. But I think we've done a lot of the work in that first sentence to help clarify what the second sentence means.
That's a good point. Roxanne.
Yeah,
Then
just
Renee.
to Bill's point, I have 14 people who work in my office, and they all make a relatively good salary as federal employees. And going into this pandemic, it was much to my surprise learned that one of them doesn't have a smartphone because she doesn't want one, and most of them don't have personal computers just because they don't. I don't know if they have iPads. I never got that far in asking, but it just came up as a part of figuring out how we were going to do our work remotely. Luckily, they all were able to take, agency equipment home with them to keep working. But I was really surprised how many of them did not have the personal devices that one would need if they didn't have their agency laptop to connect to a virtual hearing.
Thank you, Roxanne. Professor Landers.
I was going to make the same point because we have a lot of law students who don't have, the ideal array of devices that would enable them to participate as effectively as possible, with remote learning. And if they can't get into the law school sometimes to do something and to use the equipment in the IT center at the law school, then they have a terrible time getting access to some of the things they need to do. So I would say that it is not true that everyone has a device or all the devices that they need to have to work effectively.
Okay, thank you. Any other comments on this language? Okay, I think we'll leave it there. And thank you all. I think that's a better sentence for it. Judge McCarthy, is it on this point or something else in this paragraph?
Thanks,
Oh,
Amy.
yeah.
I just wonder if it's possible to go back to the prior paragraph. I was trying to do some research and went offline, and when I came back, you're on the next paragraph. But it's about the public observation of the virtual hearings. And do we know has any agency done this yet? And do we know how they do it? I know, for example, at my commission, when the commission meets, they open a public Civicom line to the public. But do we have to give the public an agency license to like Zoom FedRAMP or something? As a practical matter, do we want to say the public can observe the virtual hearing, or do we want to be more consistent with the APA that the hearing is in some form open to the public? That's my concern. So I don't know if it's appropriate to revisit that issue, but I'm not sure. I'm not sure what that last sentence means or whether we really want to say that.
Well, it's phrased in terms of agencies may need to. I mean, I suppose it depends on if the agency is even going to go there. I hear what you're saying in terms of how you logistically do that. Annika, do you have something on this one?
No, I think that's a leftover hand up.
Okay, all right. Let me see. Renee.
I was gonna, what are the federal courts doing with this question of public access and virtual hearings? I don't know the answer. Because they must have confronted this issue.
Fred, did you have any input on this from agencies who are
As far
allowing?
as the courts are concerned, it varies by courts. Some courts have been streaming as far as that's concerned. On the agency front, there was some concern on the part of a number of the agencies about how best to provide for public attendance for those agencies at which they either had a requirement to do so or thought they ought to. At least one individual suggested before they could cope with that, they had to figure out how to tell the public they were having a hearing in the first place. So the issue is I think, fairly complex. How many agencies are conducting legally have an obligation to be open? How many are open? How many want to be easily open? And there is concern about capture of confidential information. One agency in particular is deeply concerned about privileged information getting out to the public, which is protected by evidentiary privilege and such. So I think it's highly complicated and no simplistic way except, to say inappropriate cases or something.
Okay. Russell, did you have something? I thought I saw you.
Well, just what the federal courts are doing is they're making limited access available. I mean, the Supreme Court is the best example. It's rigidly opposed to having, electronic coverage of its oral arguments, but it has no choice now. Will it go back to restricting that access once it's back in its courtroom? And will some of the district courts, which under the conference regulation allow it, will they go back to forbidding it? It'll be a test. I mean, it may well be that for the courts and for the agencies, once open, it's going to be kind of hard to shut it down. But if you can't shut it down, then you deal with all the problems that Professor Lederer referred to.
Thank you. Annika, do you have your hand up for this?
No, I will figure out how to get my hand down.
Okay. Okay. I will stop calling on you. Judge McCarthy, I see.
Yes, I'm up again. I guess it sounds like it's an issue that we need to do a little research on as to what agencies are doing. My concern is that we're giving the public a right to observe the virtual hearings. And maybe they have that right. I don't know the answer to that. But they do have a right for it to be open in some fashion. Either they can listen to it. Do we want to go as far as saying they get a right to observe it? I guess is my concern.
I don't think that's what this says. But we can maybe make that a little more precise if the idea is that agencies may also need to take special measures if they permit, something. It's just flagging it that you're going to run into some possible challenges on that front based on what Fred is saying. It could be incredibly complex.
Nadine, what is I don't, maybe I'm missing something here. What is the distinction that's being drawn between observe and listen to and so forth and so on? Is one involved visual and one audio? What's the distinction here? And keep in mind, there is first of all, there's case law on, there is case law on access to agency proceedings. But more importantly, perhaps, ACUS has a recommendation, 2016-4, that resulted from a report that Michael Asimov had done, that has a specific provision about hearings being open to the public. Presumptively so. There are obviously agencies that don't allow it, SSA, for confidentiality reasons. But it seems to me we ought to at least hew pretty closely to that recommendation and try to, approximate in the video context or in the remote context what that recommendation contemplates.
And that's referenced in footnote 9 attached to this sentence, that report. Okay. Renee, did you have your hand up? No. Okay. Russell?
I just was going to ask, do the recommendations as it stand deal with rebroadcasting? I mean, if you can observe electronically, presumably you can record it. If you can record it, can you rebroadcast it?
And I believe Jeff Lubbers raised that point generally about recordings and whether that is something.
Whether the committee wants to take that on, that's a huge problem. A huge, I'm not calling it a problem. It's a huge issue.
Fred, did you find out whether agencies are actually recording hearings? I mean, obviously, when you have an in-person, typically there's.
My memory is imperfect on this, and I don't have all those notes immediately available. I can tell you that the suggestion, I don't know if it's been implemented, was made in the United Kingdom that public access could be done simply by recording court proceedings and subsequently allowing access to the recording. I didn't think that would work for the US for courts in the United States, but it may well work for agencies. Matt and Jeremy are experts in administrative law, and I'm surely not. So I would think I would spin off whatever the ACUS recommendation was.
Tristan.
I don't know if this is helpful, but in terms of agency practice, I've seen, I think, multiple agencies that are recording because they have to have a transcript to call back on, and they don't have transcribers or anything they would normally have in a courtroom. So they are recording. They have the functionality to disable external party recording, so someone could, lift up their phone and record it on their own. But presumably one could do that in court also. It's just a question of whether someone would see you. You certainly have more, you could do it more subtly, I guess, virtually. But again, technologically, they can generally disable doing that within, say, Zoom or anything else. There was one other factual question I thought someone touched on, but again, so a lot of agencies have dealt with this. I think in terms of, again, people coming on, I think that is one of the maybe more tricky things. And it seems to me that it just depends on the technology at use. So, depending on how advanced of a program one is using, right? So, we're all on Zoom here. You can use Zoom and disable people from commenting and other things to make sure they're just observers and participants. But again, I've seen various different levels of that, and I'm sure we all have in conferences and things like that, depending on how much of a wall there is between those who are observing, versus things that are a little more on the fly, right? Where it's just someone is disabled, but you could pull someone in, et cetera. I don't know if that last part makes sense, but again, technologically, there's ways to deal with it. So it seems to me that's getting down in the weeds on that's pretty hard to do if you just recommend that, or again, some have where it's required to be public, but technologically, I think there's ways to deal with that.
Okay, I go back to Tom. Any changes to make to this particular line, or is it something that you want to keep in mind as we go throughout? I mean, I do think that this is.
I just wanted to raise the issue because
Okay.
I don't know exactly what it means. I think it needs to be fleshed out. So I think we've done that. I would say that, when we have my agency has record a hearing and it's recorded, we don't permit anybody to record it. I mean, the court reporter is the official reporter. That's it.
Right.
Nobody else can record anything. But I think the sentence is fine if the committee's fine with it. I just I'd like to see how it's going to flesh out in practice. If I'm a member of the public and I say, hey, I want to observe this, and I didn't even know about it, how am I going to be able to do that? So, but I'm sorry to take us down this rabbit hole, but I saw it as a rabbit hole, and I kind of still do.
Can I share one other quick thought there?
Absolutely.
I hear what you're saying, Judge McCarthy, and to some extent, it seems to me this is already a question I would have. I think it just depends on the agencies. So at MSPB, as a relative newcomer over the past few years there, it's not entirely clear to me how any member of the public would know. MSPB hearings are supposed to be open, right? Unless someone comes and looks on a list that's in our front lobby, which is, not the practice for most things, right? Where everything's available electronically and other things. So I think just in practice, the idea that a hearing is public versus how an interested member of the public would actually figure that out and know when a hearing was occurring or other things like that. It seems to me a lot of agencies don't have that nearly as sussed out as the court systems do. So I think it is an issue, but I don't think it's unique to this, it seems, in some ways.
Thank you. Okay. Well, we'll leave it as is for now. We can think more about that. I'm thinking it might be a good time to take a brief break because we're past halfway, and I know Zoom fatigue is a real thing. So why don't we just take 10 minutes, come back at 1:45, and we'll pick back up in the preamble where we left off. So I will see you in 10 minutes. Thank you. Okay. Are we back? Is it 2:45 officially? Yes, according to my laptop. Wonderful. Okay, welcome back. Let us dive right back in. I think we had possibly completed this paragraph that begins on line 64, but I'll open it back up in case there are any other suggestions for this paragraph. Okay, great. Anything on the next paragraph, 76 to 82? Okay, next one. I know we had Jeff's comment. I have to say, reading this, I was fascinated by the idea of telepresence, and I have no idea what it is. So perhaps Jeff has a point here. Fred, would you like to explain what it is?
Telepresence in the form that Jeremy is using it is extraordinarily high-end video conferencing, best known by systems from Cisco Systems, where it is almost like literally being in the same room. The problem, both the video resolution and the audio and the layout are very unusual. They're very well done. They're also very expensive. And as best I could tell from the 12 agencies that I interviewed, none of those agencies had those systems. I do know they exist elsewhere in the federal government. If you were going to design a system where you wanted to have a remote, a person appear remotely and have it be as if they were physically in the room, this is the type of system you would get. It would also mean that you would have to have a far point with the same identical hardware and design. It would not work for what we're doing right now. I think I did define it in the report.
Okay. I mean, there's obviously some features of it in the phrase that follows the reference.
And if I could say, Nadine, it may or may not be strictly necessary to include this. I included it in the initial draft for the committee's consideration, only to drive home the point that a few years ago, the committee looked at video hearings. Here we're again looking at virtual hearings. I joked to you that we're going to look at virtual reality hearings in a few years, just to remind readers that the technology is rapidly changing in this space, and it is so important for agencies and others to pay attention to what's going on.
Mm-hmm. I think it's valuable to include. It's obviously some people are using it. It's not a pipe dream. Is it possible to consider Committee on Style coming up with some language that we could add? I'm not quite sure what Jeff is looking for. Like I said, there are some features identified here that maybe give you a little sense of what that means. And maybe Fred's report provides some good info on what it is that we could add or cite to.
Yep.
Any other thoughts on that? Great. Okay. Next paragraph. Great. Okay. Next one. That's our last one. So I would note just that the last line indicates, when agencies choose to offer, right? So again, I felt like the flavor of this is it's there as an option for you. It's not a replacement. But I think one thing that we will kind of take into the recommendation that we need to keep in mind is, I think a couple people have raised this idea of giving discretion to the judges to allow them to determine, which is essentially the agencies, but to allow them to determine when it's going to work, when it's not going to work. So I would just leave that for you to think about as we hopefully move into the recommendation. Last call on the preamble. Okay, great. So well, I guess we could start with Jeff's comment. Any thoughts on that? I'll let you read it again. Tristan.
This might be jumping in too quickly, but and there may be other reasons not to do this, but what about something like, if legally permissible, just moving that up front, agencies should consider utilizing virtual hearings consistent with, I don't know if consider waters it down too much. Obviously we're making recommendations, so kind of to have your opening shot be consider. I realize that there's that, but there's an opening thought.
Any reactions to that? Hi.
Just as a matter of, I'm sorry.
Oh. Hi, you're muted. And we'll go to Russell.
I'd actually be really curious in terms of what Fred thinks. I mean, just to the point, Tristan, of that's really big, right? Should use versus should consider using. We obviously have among the factors agencies should consider, and we certainly have they should use virtual hearings consistent with their needs and in accord with principles of fairness, efficiency, and participant satisfaction, right? Which has the pieces. I think it's sort of scary, but I sort of think that if that's going to be our recommendation, then that's what we should say. In other words, for those agencies who feel like, okay, pandemic over, back to regular life, if we actually think as a committee, there are things that are really helpful here for people, then we're saying if legally permissible, agencies should use virtual hearings consistent with their needs and in accord with these principles. So that's why I said I feel like this is the core of what we're trying to say to our colleagues and to agencies. And I think I'm comfortable just saying should use, given everything else that follows.
Well, it said should offer, which I feel is like a click
should
back.
Offer. Yes, I go back. I mean, yes, should offer. Thank you. It should be back to what it was, should offer. But moving if legally
Russell?
permissible up front.
Russell?
Well, if you take out consider, it's fine. If you keep consider, then legally permissible is modifying consider. You don't want to say that. If it's legally permissible for agencies to consider.
No. The editing didn't work. Agencies should offer.
Yeah.
Just take out consider using and
that solves
delete
the
the
problem.
change and
That solves the problem.
Tristan, did you have your hand back up?
Not intentionally, but I'll take advantage of it if I can. The one question this does bring me back to, separate from, I do think moving if legally permissible, just moving that, I think softens that effect that I also had from feeling like it's an option, it's encouraged, and then that language before made it seem a little more strongly encouraged. But again, my question would just be, to whom is it offered? Is it to litigants, which is one position in a fair and a fine position, but it's different from to adjudicators, et cetera. So it seems like more clarity would be helpful there.
So we should identify who's receiving the offer.
And if I can, one other thing, and I'm going to take my hand down while I say this, but given everything else that we have in here, I mean, I'm talking, I guess, have been vaguely up till now. From my perspective, it makes more sense to offer it to the adjudicators. The challenge of offering it to all litigants when, again, it may be that, and these are all very well, adeptly covered in the recommendations, but, for us, for instance, credibility determinations are a big deal. And so simply, there are some hearings that are going to be really complex, or where there's conflicting written record, where you're going to want to see people in person if possible. And again, agency cost considerations or other things may preclude that, but there's some circumstances where I, as an adjudicator, feel like I would really want to do it in person. So now, again, that comes from a different place than saying it's more accessible or all these, again, there's a lot of different considerations, but to me, the offer would make the most sense to me in terms of offer it, kind of through the lens of if the adjudicator in the case feels like it could be useful. And, and again, maybe from there you move to, are all the parties consenting? So again, I think a lot of these are taken into consideration down below, but that's actually part of why I moved away from offer, because it's just so vague and it would take a lot more explaining, it seems to me, to do that. Whereas if we just said use, I think a lot of the stuff below addresses the considerations that would point where it's going to be used and who makes the decision.
I do see that Jeremy is pointing to paragraph 2 of the recommendation, which builds in the idea that that the adjudicator retains the discretion. So
there may be a way.
Perhaps
Yeah.
Yeah. I see Fred has his hand up. Fred?
I was going to say, I thought it was fine the way it is, but if you're going to go further, I think it's not just to the adjudicators, it's to the participants, because they're the ones who are frequently going to gain the most from. It also is, for anyone who hasn't had a chance to read the report, it turned out that there was unanimous agreement that credibility determinations were fine, assuming that the technology is working properly. That was the one caveat that I did hear a number of times.
Thank you.
May I just jump in here real quickly? Fred, you mean when we talk about credibility determinations, are we talking about demeanor-based credibility determinations here exclusively? And then the second comment is I think the committee probably needs to think very carefully about whether it should say adjudicators should offer, if that's the language, versus the agency. And I realize there's that subsequent paragraph, but I think there has to be some thought given to who the decision-making agent here is. It the agency? Is it the adjudicator, or does it depend on the agency? Some agencies may have policies. Some agencies may want more consistency. Some agencies may want to confer more discretion on the adjudicators.
The quick response on the credibility question is I asked each time about making credibility decisions based on demeanor evidence. I was told consistently that the technology we're using today is adequate to the task, provided that we didn't have bandwidth issues that would destroy video and so on. I was also told a number of times that by the nature of the agency's hearings, often demeanor was less important because of fact-based evidence being available. But the credibility issue was consistent, which frankly, I did not anticipate.
Thank you. Tristan?
The only other, just one additional perspective I would offer, and again, I come at this as an agency leader, so people have varying motives in terms of what they want to communicate, right? So if I go and say, hey, how do you like doing virtual hearings, which MSPB did some of before the pandemic, right? And so again, people have motivations of difficulties in technology. You hear a lot of different things. And of course, then an agency, I would think, would be, again, also want to be careful of saying, yeah, we really can't tell if people are telling us the truth or not, right? But I have still heard some somewhat muted, but still some questions about that. And again, I don't know that it makes any huge difference, but we frequently at MSPB are dealing with just testimonial evidence. There's just not, it's a question of whether or not, X, Y, and Z employee did X, Y, and Z thing to someone else. And so those credibility determinations are really important. But again, I think the balance in here is good so far. I just want to make sure we don't, I guess, move any further away from those as it is, because I have still heard a fair amount of feedback of people saying they're important and that usually it works out. And again, a lot of the people I've talked to were operating within constraints that they were already kind of boxed into a lot of virtual hearings before the pandemic, just as a cost measure, frankly.
Thank you. Judge McCarthy.
I was just going to say, I was going to echo the comments that I made at your conference, Nadine, that credibility determinations is the greatest challenge in the virtual format, because observing demeanor is limited to facial expression versus total body language and personal impression in a full view of the courtroom. You're only getting an incomplete view of the courtroom. And the solemnity of the in-person adjudication arguably is lessened. But as Fred pointed out, I mean, demeanor is just one of the totality of circumstances that adjudicators look to, including the nature of the questioning, the inherent probability of testimony, evasiveness, forthrightness, consistency with other testimony, etc. So, and I've heard arguments made that looking somebody right in the face via a computer screen gives you a better opportunity to observe demeanor than looking from 15 feet away at a side profile where they may be in front of you or behind you. So I think it's an open question, and it's a fascinating one to me, because the traditional view has always been we can't have virtual hearings because you can't make credibility determinations. So I can't wait to see where this shakes out, but I think we need to be very careful about what we say.
Thank you. Okay, let's go back to this first line, which I think we're still trying to determine if it meets our needs here. I do think that paragraph 2 builds in the notion that an agency is going to make the decision. Agency leadership is going to make the decision whether this is a tool in an adjudicator's toolbox. But it's going to be up to the adjudicator to decide whether to use that tool. So I don't think what we have here in the first recommendation does any damage to that, given that we immediately follow it to, so like, okay, so you've considered all of these factors. These are some of the factors that you're going to consider in offering it and whether it's appropriate, and the judge will determine that. And specifically, paragraph 2 refers back to the principles that we've just set out. So any further thoughts about that first line? I do think that there's something to be said for, the agency kind of making that initial determination and then placing it in the hands of the adjudicators to determine when.
Dean, I'm wondering if there are some, I think a lot of the cases that we all have in mind here are the pretty formal types of hearings that are held before administrative law judges at places like Pemstrick, Osherick. I don't know exactly what class of adjudicative hearings this recommendation applies to, and maybe that's something to consider before the next meeting. But I wouldn't surprise me if there are some agencies that in certain kinds of adjudications would not want to confer that discretion. And it's just, I'm not taking a position, I'm just raising the question.
So perhaps the idea would be depending on the type of hearing that the agency offers, or the type of adjudication the agency.
I don't know if Jeremy has or Fred has a thought on this. I mean, part of it may depend on what the sort of scope of the recommendation is, or more precisely to what categories of hearings does it apply.
Yeah, that's a good question. Are we talking about just legally required evidentiary hearings? I mean, this is clearly broader than that. We talk about, I think, settlement conferences and that sort of thing at one point. But yeah, you could certainly imagine this being involved in a type C type adjudication where you have a hearing that may or may not be a trial-like proceeding.
I mean, I do think part of the problem is that the pandemic forced everybody, right, to consider using this tool, regardless of the type. And whether there are lessons that have been learned from that, oh God, these types of proceedings are just not gonna work.
Yeah. And 1A might get at sort of the nature and type of adjudicatory proceedings. Maybe it's worth exploring what that means more. Maybe the formality or the complexity of the proceeding is also part of that. Maybe there's a way to flesh that out, which gets at your point, Matt.
Mhm. Fred, did you have any thoughts on that in terms of the varying types of adjudications that the different agencies you spoke with?
It is clear there's a
Conduct.
huge number of non-formal hearing proceedings going on.
Okay.
And that seems to be remote hearing, remote technology has been especially useful for those. So the question of how to deal with this, it does seem to me that it's got to be an agency decision to begin with, and then your adjudicator should normally, but not necessarily in all cases, have the discretion to decide what to do about this particular proceeding.
Okay. Roxanne. Oh, mute.
Unmute. Okay. Just to that point, yeah, like for example, for our agency, our hearings, there's no discovery prior to the hearing. They are adversarial, but there is no discovery conducted. So people are not seeing the documents until the hearing opens. And that they've found that is can be very difficult at times because some hearings are very document intensive, and it's more difficult, more involved. But so when the judges in the town hall were discussing it, they said that going forward, they may be able to assess on a case-by-case basis that certain types of claims that they hear are less document intensive or may involve very few witnesses, or to that end may lend itself better to a virtual hearing than others. That would be very much dependent on the case before them. And so I agree that leaving it up to the judges, and the agency and the particular judges to assess the case makes a lot of sense.
Thank you.
Wait.
I think there was, yeah, that's okay. It's down. I think there was, I'm not sure who made the comment earlier about, the idea that, maybe it was Roxanne, that the idea that the parties, have to agree. I mean, there's discretion for the judge, but there's also the participants have a voice in it as well. Okay.
Oops.
Judge, oh, okay. The hands are flying. Hi, let's start with you.
Yes, just like on that last point, that was just one of my main feelings here, that I don't know if we can come up with the recommendation, but I feel like there may be situations where the adjudicator thinks it's great to have this virtually. And I think it's so important that there's an opportunity for the person to say, no, I don't want to, and here's why. Because if it's just, I want to be in a courtroom because I feel like it, or I want to see my AJ, it's one thing. But if the person says, I have a type of disability where it's really hard for me to hear, and I have found that on Zoom, it's actually easier for me to hear, or whatever else, whatever the reason is, I think of a bunch of disability related reasons. So I just feel there needs to be, and actually was on those sentences where I felt, instead of combining those two, you see, the guidelines should address, no, could you stay back where you were? Because that was very helpful. It really pulled out the point. Where was it? The guidelines. Yeah. So A is they should have guidelines about the process by which participants can request to participate virtually. So maybe the adjudicator didn't think so, but they want to ask for it, and then at least that person has to think, well, okay, would it be okay? Circumstances in which the individual's virtual participation may be inappropriate. That's almost like B after A. They ask for it, and then you say, no, it's not appropriate. C, any process by which parties, representatives, and other persons can, as appropriate, object to or express concerns. And I don't know, circumstances in which it is appropriate to grant the request, not to have the virtual hearing.
And this is part of recommendation 5.
Yes,
But
so
does it raise the question of whether we need to flag that or incorporate that somehow at the outset? Now, there is a phrase that says participant satisfaction, right at the top.
Yeah, and I noticed
So
it
that's-
mostly when I got down there, and I think that's participant satisfaction is good. I don't think I had something up here. It was just because you raised it, Nadine, sort of
Their
generally.
ability.
You said someone had raised that point, and I was like, yeah, let's just be thinking about it. But but I think these were okay. I don't remember stopping on something here.
Okay. So let's go back up. I mean, it sounds to me like we're in agreement, at least on this opening line. And the idea being that we're going to flesh that out a little more later in terms of those objections, for instance, or the discretion that comes in on paragraph 2. So any other, speak now, we're going to move to the factors if that first line is in a good spot. Okay. So I love our lists. We always have lists of great factors. They're examples, right? They're not the whole world. So Jeremy has explained that A through E come from a prior recommendation, a little bit of tailoring to the virtual hearing concept here that we're trying to work from. So any thoughts on those? I know E we need to make consistent with the prior change that we made. Thank you, Jeff. Judge McCarthy.
I guess if this was to reiterate my concerns I expressed at the outset of the meeting. When we use the word adversely affect in D or impede in G, I would like to see that change to adversely affect or enhance, or would impede or enhance. I don't, I think we want to be neutral. And with regard to neutrality, I question whether we want to use the word outcome in A, or some would suggest that to me that we're looking for a particular outcome. Maybe the agency is, but as an independent adjudicator, I'm not, and I'm looking for, you know, the due process in the hearing. So those are the concerns that I have.
I think that Jeremy can clarify here. I think that the intention here was to be in accord with what Judge McCarthy just said. And I think this provision draws in part on the earlier recommendations. The idea basically is that this should be the decision, the use of any kind of virtual or video hearing should be outcome neutral. I think that was I think that's what's trying to be conveyed here.
That's correct. Actually, I think I may have editorialized with the word adversely from the earlier recommendation, so I will remove that. And some of these other ones sort of combine recommendations. There was a very long list in 2011 for, I mean, it's up to the committee whether the committee wants to reproduce that entire list or combine them in balancing costs and benefits. But B and C in particular sort of combined 2011 4 and 2014 7, which was the other video hearings recommendation.
Judge McCarthy, did you have your hand up again?
Yes, I just have one more concern in the factors. It's number H. I mean, I think there's always a reasonable concern that there could be improper interference in a virtual hearing, and that it's the adjudicator's role to set up guidelines to guard against that. So I throw that thought out there because it seems to me that's always the case or something we should be concerned with. Whereas with an in-person hearing, presumably the judge can see everything that's going on in the hearing and issue a sequestration order, and everybody can see any possible coaching or tampering with witnesses or communications, things of that nature.
It does seem to echo the language of A.
There's always that concern, but maybe it's not a concern to others. But I think it's just a tautology that you got to be aware of this stuff in a virtual setting.
Yeah, I wonder if H is covered by A. I mean, obviously it's a specific concern, but it's the idea that can it be used without, we're echoing that language, without affecting the outcome is the same language that's in H. Is it covered by use of, I can't remember the language above, whether virtual hearings can be used without adversely, nope, we're not saying adversely, without affecting. So do we need H? If that's kind of a universal concern that I think that's what you're saying, Judge.
And G has the same formulation.
Oh. No, that's the credibility issue. Hi.
I think there may be some utility to pulling it out. Again, I'm just sort of thinking about folks in the agency, a little bit higher up in the agency, who aren't sort of on the ground doing the hearings. If they're getting pushback, and part of it is, look, I have found that this isn't about new, as the judge said, this is always an issue. But I mean, I think G and H both have that. I feel like there's some utility to that. Also, if this is what we've said before, not sure I want to pull something out and it looks like, why was it pulled out? So I think it's fine.
Maybe we don't need to repeat the and thereby have an adverse effect. Maybe that kind of goes without saying. And the idea is that,
oh, yes, exactly. On line 39 to 40 and on G, whether would impede and also, I mean, think
just
that's
state
exactly
it
right.
without the thereby.
Yeah,
phrasing.
Without the thereby for both of them. Okay.
Oh, Kent. Yeah.
Actually, that one line was relevant to something I was thinking about. I think if you can go back up to, I think it was A again. The line where it says affecting the outcome of cases, I wonder if it's better to say affecting the fairness or outcome of cases heard, because I can imagine that much of this is about process. It's not about the substantive end. And if we're concerned about how the litigants think about the process. I can think of various things where it's going to affect how they might see the ability of them to provide their side of the story, you know, in some way, or what the witnesses were like. But we still might reach the same outcome no matter what. And I think it's probably better to take it out, as Hy had suggested, or where you had suggested, down below, and then also make that addition in A.
Any thoughts on that? Hi, did you have another comment?
Well, I would just had a clarifying question to Kent. Are you saying to add the way it is there fairness or outcome? Because that seems a little odd. I mean, the whole point is the outcome should be fair. So,
I think I was suggesting, I was thinking of the fairness as being more procedural and the outcome being substantive. So when you say affect the outcome, I would think that would mean the end result, whether you're getting benefits or not, whether you're getting the license or not, as opposed to how you.
Oh, I see. Right. And then the procedural fairness is sort of some of what we have in G&H.
Yes.
And that's why you can take it out because it's referring without affecting the procedural fairness or substantive outcome. Actually, I like that.
I like that too.
Yeah, I prefer the adjectives too.
Yeah, I really like that too, Nadine. That was what I was trying to say, but Ken can obviously say it more eloquently than I can. So thanks, Ken. I think that's great.
Roxanne.
Well, I raised my hand only because I wasn't sure that I liked even raising the issue of outcome, because, you know, there's no way of knowing, did it affect the outcome? Did it not? I mean, you're going into it hoping that it, and planning that it won't. The best you can do is not affect the procedural fairness and protect the integrity of the hearing. But, you know, I'm also fine with the substantive outcome if everybody else likes that language. I was just going to suggest that we say instead affecting the procedural fairness and protecting the integrity of the hearing or something like that.
Any other thoughts on that? I hear what Kent's saying, that, you know, it's more about the process that you take, the, you know, the roads that you take, the process you take to get to the end result, and not necessarily the result itself. But
Nadine, if I may here, I do understand the distinction, but it is an important point that ACUS did make, and Jeremy, correct me if I'm wrong, in 2011 about affecting substantive outcomes. Now, that was in the context of mass adjudication programs where, you know, agencies have or could undertake statistical analyses of outcomes to ensure that there's no adverse effect as a result of the form that the hearing takes. I don't know if Jeremy has any thought on that, but that the idea of outcomes did refer to to the extent this is drawn from the earlier recommendations, it is referring to substantive outcomes. And some of the adjudicators were, especially in the SSA context, have been very concerned about the question about whether video hearings do affect on a significant statistical basis substantive outcomes.
Yep, that's exactly right. You've seen it in the immigration adjudication context as well. Questioning whether cases with rather similar fact patterns turn out differently. One's video, one's in person. Was it the form of the hearing itself that actually caused the difference in the outcome?
I'm not sure the NLRB, for instance, would be in a position to conduct that sort of evaluation in the same way that EOIR might, or SSA, so forth.
Thanks,
yeah, we don't have to do a statistical analysis.
Any other concerns or thoughts on this language that we've revised? Okay, we'll leave it. I'm looking to see, I think Judge McCarthy, on D, would it be better to just say neither enhance, you know, just say affect?
I think so.
E. Okay, same with E.
I think so.
We need to conform F to the changes we made earlier. But I think we want to retain the last part. Okay. G and H. Any other thoughts on those?
Okay.
Russell. Oh, you're muted.
Everybody's better off when I am. What we're really talking about here, do you want to say anything at the outset? This is really a matter of balancing a variety of factors. It doesn't say anything anymore, but that's really what we're doing. That's what we're suggesting. It's you know, you're weighing cost and benefits, and you're defining cost and benefits rather liberally, but it puts it in context anyway. Just a suggestion.
You would do that at the outset here where Jeremy is.
Yeah. Otherwise you get into each one, but just, you know, alert agencies that we're recommending they do is evaluate pros and cons, is, you know, put it in more better language than that.
Does the balancing aspect, could that replace this in accord with? I mean, well, I guess you don't really balance, well, you're balancing fairness. You're always going to have fairness. Maybe that's not a balancing.
Yeah, but you're always balancing. I mean, you want 100 points of fairness, you know, take off one from 100 for 1 point of efficiency. That, you know, those are all factors judges are always weighing. I don't know, just a thought, because that's all we're talking about here is weighing one thing against the other.
Does the language that Jeremy's come up with, does that address?
Yeah, something like that.
Okay. Might need some committee on style there.
Yeah.
Yeah. You have an idea, Hi? That's okay. No, it's fine. Never mind. I know.
No. What I was going to say is, you know, agencies should balance the factors noted below, you know, and I don't even think you need when considering, you know, should offer consistent with your needs, should balance the factors.
Maybe that phrasing below. That Jeremy, Jeremy, I think that might get us there.
Put my hand down because I was like, you know what, the committee on style will figure out that we need something like that.
Yeah, great. Okay, thank you, Russell.
Yeah.
I think we can swing back down now to, I think paragraph 2. I think we've gotten through those factors. So this is the discretion point we alluded to earlier, and it does refer back to the principles that we just listed. Any thoughts on paragraph 2? Paragraph 3. We have comment from Jeff, sorry. And this is, I think, echoing the point that Judge McCarthy raised about, was it Judge McCarthy? It's been a long couple hours. No, somebody raised about opening these these hearings. I think it was the judge. So Jeff, you can read Jeff's comment. Again, this is consistent with prior recommendation, as Jeremy's got in his comment. I do think it's consistent, obviously, with what ACUS has recommended in the past. So, and there is the option to close it.
Yeah,
Well, the
Nadine, I
training-
missed that. I missed that. I think that's great. So thanks for pointing that out. That addresses my concerns.
Okay. Now, Jeff is talking about the mechanics of it, which I think we alluded to in the preamble where we said there may be measures, you know.
It's somewhat addressed.
Okay,
further.
thank you. Thank you, Jeremy.
Yep.
Okay, maybe we cross that bridge down there. Well, whether and how would cover, I think, some of the logistics that Jeff is asking about. I mean, there's also this idea of confidentiality and okay. Recording the hearings.
This was a general comment
Well,
from Jeff. Yeah.
Yeah. Fred.
I suggest changing 3C to just the word confidentiality, because it's far more than business documents that are potentially involved.
I think that makes sense.
Yep. That was in 2016-4, but I think it's the same idea.
Mm-hmm. Russell, you have your hand up.
Just in the recording context, Judge McCarthy said earlier that his agency prohibits parties from recording hearings. I just keep coming back to the idea that this forum creates an incentive for people to do various kinds of mischief, or maybe not even mischief. I mean, the rare hearing that the news media may be interested in. Do we want to say anything that now that these proceedings are being electronically stored somehow or other, and participants have access, agencies need to worry about individuals who may try to use or misuse the hearings, or take steps to be sure they can prohibit recording by outside parties? Or is that just not a big problem? I just don't know.
Fred, do you have any insight on that?
Advocacy groups would love to get recordings, it seems to me, of immigration court hearings and showing.
The whole question of recording is a very broad matter that I frankly don't think I or many of us know enough about at a particular point. There's, generally speaking, I was told consistently from the 12 agencies that their pre-hearing orders indicate no one is allowed to record. That's distinct from what someone, as has already pointed out, could do.
Right.
Then there is the question, at least one agency expressed an interest in using specifically Zoom's recording feature to use as their recording. That agency was concerned over the fact that Zoom owns the technology and the recording. I opened that topic with some senior management for Zoom a week or so ago and have not continued that conversation as yet. So I think the question first is legally, and again, I defer to those experts here, and I'm not one, as to what it is the agency wants to do and legally can do. And then we might have a technology resolution.
Thank you. Kent.
I'm not sure still what I think about what should happen to the document itself, like whether we revise it. But one thing that I thought of when just reading this was, is this something where agencies do need to, I think much like Judge McCarthy was saying, just need to get ahead of this a little bit? Because I was already thinking of like deep fakes coming out, and you've got these interest groups coming in and they can take somebody's witness testimony and make it into something completely different, and they have full access to it. And we're just at the beginning of that right now. I'm really concerned about where this goes, and anybody can take this over and use it. And I don't know, kind of like Fred suggested, if we know enough about how to actually deal with the problem yet. But if I were in the agency, I'd for sure want somebody to go digging into this before we opened it up to everyone.
Great point. Judge McCarthy.
Yeah, I would echo that point that Kent just made, and I would just point out the interesting issue that apart from the parties recording the conversation, if the agency has a separate recording that becomes part of the official record of the actual video, that raises the interesting issue that the agency can view the same demeanor credibility-based resolutions that the judge has made. And agencies may want to seriously consider whether that's wise or unwise. I don't know where that goes, but it's an issue that I see looming out there.
Thank you. Hi.
So, I hadn't focused on this as much before, but I think this is really important. So on line 155, 156, do we want, and this is sort of off of Kent's point, do we want to say for this document, for virtual hearings that are open to the public, agencies should provide a means for interested persons to attend the hearing and view a streaming video of the hearing? Although, by the way, attending and viewing streaming video, I think is the same in terms of attending the virtual hearing. But I have a question for those who've been doing these. If you before had used a court reporter, do you then just still have the court reporter in this virtual hearing? And that's what you were using for your record? Yeah, okay, right, I could ask, but because then you have a lot more control over, and then presumably people are able to get that transcript, right? That court reporter transcript, they allowed that. So, so I think here, we don't have to say anything about that, because if you have a court reporter, then that's already, that's your background norms. So maybe we just want to say for virtual hearings that are open to the public, agencies should provide a means for interested persons to attend the hearing via streaming video. And then that's it. And then make a point, and I think we can just do that in the preamble. By the way, agencies, think about the recording issues. If you have a court reporter, fine, but like I'm pretty sure in EOC hearings, I don't think they had a court reporter. I don't know, but I don't think so. But I really like the idea about thinking about recording, because sometimes, like at EOC, if you were reviewing an AJ's opinion, you could see all the papers, but you couldn't see a recording. They were definitely transcripts. We could see the transcripts. So I just think there's really pluses and minuses, but I don't think we should here say, yes, they get the recording. Let's do it the same as you could do with the live one, and take out or access. I mean, I would say from our recommendations right here, we take out, like you're saying, we take out or access, and then we don't have a recommendation, because based on what we all said, I don't think we can have a recommendation yet. It's pretty complicated.
I agree. Kent's picture of what could be made me think twice about that. The idea that you could manipulate a recording into something that it can't be verified. So let's say we take that out for now. I think that's the suggestion on the table. Any thoughts to that suggestion? Now, it does open up the question of what are we going to say about it? You know, are we going to say anything about it? Or are we just going to say that we're not saying anything about it?
One thing I would bring to your attention as well is in agency appellate systems last season, it references openness of proceedings to the public and availability of video or audio streaming or recording, which is fine to debate, but yeah.
Yeah. Yeah.
There may be a way
wonder,
that
well,
the agency should consider whether one of these is appropriate or not. Maybe wide open proceedings that are already wide open, a recording is fine. But for a immigration proceeding, for instance, maybe a recording would not be proper.
Can I just add to that then? I think that we definitely should talk about the recording issues in the preamble, because a lot of people will not have thought about this. So I think we do that. I'm not averse to maybe saying as a separate thing, you know, agencies should carefully consider whether they want to have the recordings available as well, but it's separate from the sentence that says agencies should provide, you know. And then we've laid out in the preamble the things they can consider in doing that.
Yeah, I was wondering if maybe a separate, you know, should consider, do they want to record it? Is that something they even want to do?
Question. Exactly.
And then if they do, how do they safeguard it, or how do they share it? Do they not share it? It obviously becomes a record. Is it a foiable record? I assume it is. I think we should maybe give that some more thought. Tristan.
Yeah.
Just you actually touched on it, but I was going to say in terms of FOIA, I mean, again, I've seen, you know, for instance, we are recording, and I'm not positive whether it's a video or just an audio recording, because there's some interesting questions about the video recording, but and then we don't have transcripts for everything, but whatever you create, if it would, you know, again, if a transcript would be available, then a video recording is going to be a record as well. So I think highlighting this could be helpful, again, whether it's up front or down here, but just noting that fact, because I think a lot of folks haven't thought about them. And to circle back to what someone mentioned about Zoom, at the beginning of the pandemic, there was a lot of back and forth. I know our agency had it with Zoom. I think maybe some other places did too. I know we were having it with FedRAMP or whatever body administers, I don't know that as well, but to ensure we knew that it was FedRAMP certified, but it did raise this question of what access does Zoom have on their end? And so again, I just ensuring that these are government property, that no one else has them. And then again, agencies just need to be deliberate in determining which records they create. Because again, I think you'd have a harder time if you would otherwise make a transcript available, you'd have a harder time withholding that. A video, you don't have to transcribe it for someone, but again, if you're thinking for some reason that these are going to be different, then I think there's a lot to consider there, because it's not clear that they would be.
Well, I think that's something we should think about in terms of making a separate recommendation about whether agencies want to do that. I can only speak to my agency's experience with recordings. I know when we've had oral arguments, which we don't do a lot, but I know FEMTRIC does a lot, we've recorded them and posted the recording on the website. There's something about the video, I think Kent really hit that for me. The idea that there's video that you could share or would be foiable, that could be manipulated in a way. I suppose you could do it with a recording as well, just an audio recording, but all of that is definitely food for thought and something to think about.
One alternate idea, rather than, I know I said before, maybe just put it up top, but one alternate idea would be even in the recommendation to just bake in without a recommendation, right? So agencies should provide a means of people attending, and then just agencies should carefully consider what records they create, or what, you know, consider the implications of creating and maintaining a recording of whatever, just to flag it without, it's not a substantive recommendation to do something one way or the other, but just to, they better think twice about it, whatever they do.
I just want to say though that that should come after via streaming video.
I
Just
agree.
logically, right? Yeah. Provide a means via streaming video and
It might even be cleanest just to put it in a separate sentence, so that, I mean, again, you've got one that is a straightforward recommendation, and then again, one that's just kind of highlighting other stuff to think about.
I mean, I think Jeff makes some interesting points in his comment about who edits it, if there's hot mic type comments at the beginning and end. I mean, obviously with a court reporter present, those things tend to be naturally edited out, I think. And then the parties have an opportunity to review the transcript and submit corrections. Yeah,
Maybe this is
a
nitpicky,
whole
but I
new
would,
world. Go
Sorry.
ahead, Tristan, sorry.
I was gonna say, but I would say agencies should carefully consider, and then I don't have a good edit on the tip of my tongue, but again, I'm trying to think if there's a way to just point folks that it's not just a question of creating a recording, but again, the records and other, I don't know if we want to be more specific, or, and again, maybe we want to see creating and maintaining a recording, but I don't know.
Fred?
I just want to clarify that if an agency streams, we can capture that. So just the fact that we're putting in streaming will permit an unofficial record. And I don't think it's germane to the current conversation, but just to supply information that might be of interest. 2 years ago, we demonstrated the world's first artificial intelligence-based automatic speech-to-text court record. So all those court reporters that are currently being used and you've been referring to are going to be technologically obsolete much sooner than people think is likely. So we're probably going to be doing audio recording or audio video recording, producing a digital text record.
Wow. I feel very old, Fred.
And of course,
I do that on a constant basis.
although of course, post-pandemic, you can imagine streaming video in person, right? That would be an option as well. Have an agency room set up where one could go watch a video of the hearing, or at least watch a hybrid video hearing. So I guess that's a
It is, by the way, suggestion we have made for courts, single most limited way of solving the problem, and is arguably particularly usable if we don't have a pandemic.
Roxanne.
Just wondering if it makes sense for this language to say instead, for virtual hearings that are open to the public, agencies should provide a means for interested persons to attend or view the hearing, period. I mean, when we were starting ours last year, we spent a lot of time talking about how to make that happen. And we quickly decided no for recording, and ultimately decided no for streaming for kind of the reasons that Fred was saying. But we have figured out a way to allow people to attend the hearing who aren't necessarily case participants, because they are open to the public. But I think each agency will have to think through all these many things along, like the FOIA things that Tristan mentioned and all of that. I think agencies will think that all through. I just don't know that we can possibly list through all the things that could worry us. Us attorneys being professional worriers, we will worry about a lot of things. So trust that we will do that.
I love that, Roxanne. So the idea would be to just stop the sentence, attend or view, and leave it to the agency to sort out the format and how that's going to work, and take the rest out. Was that your suggestion, Roxanne? Yes. Okay. Any thoughts on that? Just going the simple, we're not going there route. Tristan.
Should have waited a minute to see if anyone else had any thoughts. I hear the point that certainly attorneys will think of things, and I think to me that point would mitigate for not giving any further detail in terms of like records or other things. But I will confess I still like the idea, or I would still advocate for the idea of having just agencies should carefully consider the implications, because notwithstanding, we were an agency full of attorneys, and still people do things sometimes that are just viewed through one lens, right? Our adjudicators don't fulfill FOIA requests. They don't handle FOIA appeals or other things like that. And so again, I just sometimes folks with one set of responsibilities don't always consider the wider agency implications. But
That's a good point.
But again, I think if folks felt like we should keep something there, I think the point of just again capping it after creating a recording or something like that would be sufficient, just as a little place marker and nothing more.
Hi.
I was going to say pretty much the same thing. Like when it got deleted, I'm like, oh, no, maybe undelete what you just did. In the sense of, I think you can just have that sentence. I love the attend or view, because it lets them decide, is it attend or view? And then for agencies that are thinking about view, agencies should carefully consider the implications of creating recording. Some of them already are, some aren't. And then in the preamble, we can talk about some of these things that people may not have thought of. So I think that does it, those two sentences. But all that stuff, what can they do? Just keep that in a comment, because you're going to want to put that in the preamble, right, address the preamble. Great.
Great. Any other thoughts here? Thank you, Roxanne, Tristan. These are all, and Jeff, I guess, who kind of got us started on this path. Kent, the parade of horribles. I'm still don't want to think about it. Okay. Are we close to time? I have lost track. Oh, we've got a few minutes. We can do 4. Anything on 4. Now, obviously, this is critical, I think. You got to have the hearing itself has to be protected, the information that's provided. I wondered myself if this adequately captured every possible consideration that we're worried about here. Any thoughts on this one? I mean, is it okay, Judge McCarthy?
Yeah, I was just going to echo what Tristan said earlier about FedRAMP. There was the Zoom bombing at the outset at the beginning of the pandemic, and many agencies said, we can't do Zoom without government security. So the Federal Risk and Authorization Management Program, the government-wide program, provides a standardized approach to this security assessment. And I don't know enough about it, but I know that FedRAMP is a very important aspect of why agencies have been able to use Zoom. Like, for example, when FMSRIC has a Zoom hearing, we had to get the Secretary of Labor to buy off on it. And since we provided the Zoom software through our license agreement with FedRAMP, they could buy into it and participate in our hearings. So I throw that out there for thought. I don't know enough about the Federal Risk and Authorization Management Program, but I think that's why we're able to do what we do.
I'll just add that 4 seemed to me about the information that's provided, as opposed to something like that consideration, like preserving the security of the hearing itself, which we kind of hit on in 5D, perhaps. I should be looking at my paper. Kind of. So I wondered if maybe 4 should just be more robust on the tech side. Roxanne, you have any thoughts on that?
I was just going to say that I read 4 the same way that Judge McCarthy did. I thought that was talking about the security of the hearing and not just the documents. I mean, for us, we purchased licenses to Zoom for Government, which had built-in security to it already. But certainly it was a concern, which is why we tried to find a product that would work for us. So I don't have any language suggestions, sorry.
That's fine. No, that's fine. Jack.
Yeah, I was just going to say, I don't think it would distract from the point of number 4 to add another clause. I have, you know, it's hard to draft on the fly, and I just came out of my class. But something like, and also to ensure that the integrity of the hearing process, or something like that. You know, something like that.
Thank you, Fred.
I just want to make clear that the specific origins of this is the fact that some agencies are dealing with classified information, and it is the underlying information that's critical. There's nothing wrong with extending this, and I suspect that either Jeremy, or if he'll give me a shot, we can deal with the basic hearing itself. But this is because most agencies don't have this problem, but there are a few that have a very critical problem.
Okay. Okay. I think we are close to ending our time here, and perhaps we can resume with that point next time. We still have quite a bit to go. We do on the recommendation, but we'll have our full time on that next meeting, which is 2 weeks.
May 4th.
May 4th.
Yep.
May 4th.
Can I just make a really quick comment before we jump away?
Oh, yeah, absolutely.
Sorry, I think in what we added there, I think you want to remove the that just to ensure the integrity. We probably would have caught that coming back, but.
Thank you. No, good to do it now while we're here. Okay. Any further closing thoughts before we sign off? And I thank you all for the great work, as always. Document's already much better than it was. It was good to start with, Jeremy, but
it's much better.
Yeah, no, great work. And I hope that you all can come back on the 4th and we can wrap this up. So thank you very much for your time, and get outside. At least here in DC, it's beautiful.
Thank you, Nadine.
Thank you.
Thanks. Good to
Such
see
a delight
everybody.
to be here.
Bye-bye.
I think.
Take care.
Thank you, Nadine.
Bye-bye.
Amazing as usual hosting.
Thank you. Hi.
Absolutely.
I wanted to tell you while I have you, we apparently
Yeah.
have friends in common that I didn't realize. Kim Tilley and her husband, Peter. Do you know Kim Tilley?